this unit, we are going to explore the common law sources of law. Within the Anglo-American legal tradition, there are 5 sources of law. We have international law, constitutional law, statutory law, administrative law, and our favorite, judge-made law. Let's explore each of these in turn, but first, let's put international law aside. International law is the law between governments and international organizations. For our purposes here today, we're going to look at the domestic elements of the law. So let's start with constitutions. What is a constitution? Or interestingly, does Great Britain have a constitution? Yes, it does. But it's different than the American Constitution. The American Constitution is written. It's an actual document. But Great Britain does have a constitution, but its form of constitution harkens back to the true nature of what is meant by a constitution. Great Britain's constitution is constituted of the body of law that has evolved over time, regulating its society. So the British Constitution is a collection of laws rather than a single document. By contrast, the U.S. Constitution, as we have explored in several of our units together, is a document that evolved through a very difficult period of time and negotiation. But for me, the concept of what a constitution truly is somewhat similar, if you would think of it this way for a moment with me, somewhat similar to the process you go through when you register a company to do business. When you register a company, a new company, to do business with the government, you file what is referred to as the Articles of Incorporation. And the Articles of Incorporation basically set out very clearly in the record who you are, who your shareholders are, what resources you bring to this new business, your business purpose and business intent. In essence, it clearly defines the nature and scope of your business and who is involved in the process. In many ways, a constitution is similar. It says who you are, we, the people. It says how you hope to accomplish your governance. It defines the rules, it establishes the structure upon which this new nation evolved. So in some ways, a constitution is similar to a corporation's registration. They're articles of incorporation. All right, that defines constitutions. Let's take a look at statutory law, our second form of the 5, excluding international law, if you will. What is statutory law? Well, statutory law, very simply, and we've spoken about this before, statutory law is legislative law. It's the process of the legislative process. Negotiation, deliberation. So that's statutory law, and again, very similar to civil law, very similar to the civil law process. So we have constitutional law, statutory law. How about administrative law? What is administrative law? Well, in actuality, it is connected to statutory law. Administrative law is a process. It is the result of legislation. Let me give you an example. Every legislature in the world works hard to legislate various sectors of their economies. we expect an awful lot of our legislators. They're just human beings like you and I, and yet we expect our legislators to deliberate and render decisions over questions of law that touch all aspects of our lives. At times, that's not easy, especially in some areas of our lives, some elements of the economy that are highly complex. So the example I will use to describe the administrative law process for you is that sector of our economy in the United States that regulates food and drug. So we've said that administrative law is the product of legislation. The first step in the product of legislation that ultimately regulates the food and drug sector of the U.S. economy was an act entitled the Food and Drug Cosmetic Act. It was a statute. But within this statute, the Food and Drug Cosmetic Act created an organization. Created an organization that was given the power to make law. You've probably heard of it. The Food and Drug Cosmetic Act gave rise to the FDA, the Food and Drug Administration. And the FDA was empowered with the ability to create law. The thinking was, of course, that this group of experts would be far better at the process of legislation because they were specialized. They were specialists in this field. So the Food and Drug Cosmetic Act gave rise to the Food and Drug Administration, and that is administrative law, administrative regulatory law. All right, so constitutions, statutes, administrative law, administrative regulations. That brings us to our familiar friend, the fourth of our fifth, and again, we're excluding international law, brings us to our old friend, judge-made law. Now, we've spent a good bit of time describing this process. What is judge-made law? What is the common law? We've compared it to the civil law. We've spoken of its strengths and weaknesses. Strength of judge-made law is speed. Its weakness is the potential for divergent opinions. We spoke of the speed and strength of the civil law tradition. But there's an additional element we need to explore with regards to the common law. Judge-made law is very special. And the judge in the U.S. courtrooms has a great deal of power. She has the power to create law here, today. But that power is not absolute. That power is bound by two fundamental principles. The first of those two principles is the concept of precedence. The second of these two principles is a concept of stare decisis. Let's look at each of these in turn. First, the concept of precedent. What is precedent? Precedent, that which binds the U.S. judge. Precedent is the idea that if this question of law, if this issue before the court within this same jurisdiction has been entertained before, has been asked and answered before, this previous case to the concept of precedent should bind the court today. We don't want to reinvent the wheel each time. So if a case with a similar question of law and substantially similar facts has been dealt with in the past, then that case from the past should guide the court today in its deliberations. That's the concept of precedence. The concept of stare decisis, the second of our two binding elements, which is defined literally as, from the Latin, the phrase, let it stand. Stare decisis entails a situation where the court in the past is dealing with a question of law that is not just similar to the issue presented in the court today, it is the same question of law with substantially similar facts. And when the same question of law is addressed in the court today as it has been in the past with substantially similar facts, we have stare decisis. Let it stand. And the court is bound by that decision. Now, we say that precedent is binding and stare decisis is binding absolutely. But the reality is that both of these concepts are flexible. Both of these concepts represent the starting point for the court's analysis. It's not that the court must follow these cases blindly. They are not bound by these decisions absolutely. They serve as a starting point from which the court's analysis must begin. So we say not that a court must follow the opinion from the past in its entirety. We say that the court must begin its analysis based on these cases from the past and reconcile their opinion today. They may ultimately choose not to follow it for a number of different reasons, largely connected with public policy and other more human elements. But the reality of these binding concepts of precedent and stare decisis say very clearly to the court, you must begin your analysis here. We want consistency in the law. There are some aspects of the common law process that are both science and art. Now, what do I mean by science? Well, by science, I mean the scientific method. The scientific method can be defined as a process whereby you set up a proof, and no matter how many times you run that process, run that proof, you have the same result. That's the scientific method. And part of the common law tradition is scientific in that sense. But the other part is truly art. The other part focuses on the very human aspects of the law, focusing on public policy, social values, and the future direction that the law should expand in. So there we have it. Our exploration, if you will, of the sources of the common law, the Anglo-American legal tradition. In our next unit, we will explore in more depth the role of the judge in this judge-made legal tradition, as well as explore some elements that can be used to aid us in reading U.S. case law.
Professor, could you describe for us the role of the trial court and the appellate court in the United States court system?
Excellent, excellent. Well, the role of the trial court and the role of the appellate court is quite distinct within the U.S. legal system. The trial court is the first level court. The trial court is the finder of fact. It basically has two principal roles, two principal jobs: determine what happened and to apply the law to those facts. Now, we limit the trier of fact to the trial court level for a number of very rational reasons. We limit the determining of what happened to the trial court because the trial court is closest to what's happened, not only geographically, because that court has been seized of this issue that's closest to the locus of the claim, but also it's closest in time. we know that the appellate process takes time. And the trial court is the first court seized of the issue. And so we limit the trying of fact, the determination of what happened, to that first level court. The second element of the trial court's role, its job in this system and process, is to identify the law that should apply to these facts. So identifying the facts is crucial. You change the facts, you change the law. So it's a very important role. So that's our first level court, our trial court. The appellate court's mandate is broader. The appellate court's mandate is to maintain consistency in the law. So they're very definitely examining the trial court's opinion. They are looking to the past. They're looking to precedent that was used in the application of the rule to the facts in this case to make sure that the application of precedent is consistent. But they're also looking to the future. The appellate court's mandate is broader. They look to the past to ensure the continuity of the law, but they have a mandate to push the law in new directions when necessary. Now, we spoke in one of our earlier units about the potential for a split in the jurisdiction, where two courts presented with a relatively similar issue, a relatively similar question of law, and substantially similar facts reach opposing opinions. And we've said that it's the appellate court that resolves this split, because when you have a split, a judicial split like this, in essence, the two opinions negate each other, and we have no law. So the appellate court, in instances such as this with a judicial split, will examine both opinions and decide which of these two opinions is the best direction for the law to move in. So, once again, the trial court is the trier of fact, and it applies the law to those facts. The appellate court's mandate is broader. It looks to the past to maintain the continuity of the law and ensure that there is no error in its application. And in this process, it also looks to the future and moves the law in new directions when it feels it's necessary. It's a good question.